In this session, we'll discuss the unconstitutional practices of the child support program in South Carolina. The Health and Human Resources stated that there are 1 in 4 children in South Carolina that's touched by the child support program, and that includes both private cases and what we call DSS cases or welfare or TANF cases. Later on, we'll discuss the differences between private and public. The guidelines for the child support program in South Carolina is found under Title 63 of the South Carolina Code. That's Chapter 17, and it's Section 63-17-310, which is called the Family Code. In this session also, we have a quiz. We have a bonus at the end of this video called Motion to Vacate an Order and Jurisdiction. Let's get started. Hello, my name is Chris. And in this session, we will discuss the unconstitutional practices of the South Carolina child support program. As always, we said, please support our channel and please support our ongoing research. We accept donation via PayPal or Cash App. And our identification is ChrisH289 at protonmail.com or ChrisH289 at Cash App. You can also hear us on podcasts. We're on Spotify, Apple, Amazon Music, so that you always have the availability to see what we have to offer. We did a series, or we're on a series called Lawsuits. And if you have not checked out Lawsuit Against Your Employer, please do so. It's an eye-opener. So let's look at South Carolina's child support program. 45 CFR 32. That is the administrative garnishment for South Carolina. And it's been consistent over the last 5 years. It ranges from $183 million to about $190 million. In 2019, they had $183.4 million collected via the garnishment program. The recent 2020 Census Bureau stated that there are 5.118 million people in South Carolina. And that year, 20,170 men signed the Acknowledgement of Paternity program. Now, South Carolina, in terms of ranking of the overall spend by 2019, they're not within the top 5 or within the top 10. They're somewhere around within 25 to 30. Now, we reported back in 2019 that the South Carolina program started what is called the PAC system, which is the Palmetto Automated Child Support System. That is, they moved to a new payment system that creates an automatic income withholding electronically. In other words, there are no signatures. Now, here, this is a press release from Ernst & Young that says South Carolina employers must now send child support withholding money to the disbursement unit. Now, I'm not saying that Ernst & Young is involved in a child support program. I'm just putting here on the screen, which is a public statement, that what I'm saying is actually true, that a white shoe firm as Ernst & Young says they did implement their child support program in 2019. So let's look at the code itself. South Carolina's child support code is Chapter 17, Section 63-17-1070, and it's been in effect since 2020. One thing was noted throughout the program. We found a section which is called the enforcement. We're always concerned about enforcement because our goal on this channel is to help you avoid enforcement. In Section 63-17-1070, there's a section called the contempt, where you are charged with a misdemeanor in contempt. And it states here that if you are guilty of a misdemeanor and you're convicted, you can be fined up to $1,500 and be imprisoned for up to 1 year. Now, I have the label here that says this is a due process violation and it's unconstitutional. Do you know what I mean by that? Why is it a due process violation? Well, here's the reason. It is true that the United States Supreme Court said that where a court may impose a sentence in excess of 6 months, a contemptor may not be denied the right to trial by jury. Yes, it is trial by jury, not jury trial. Many people say that they're not the same. This is trial by jury. Also, the Supreme Court says that even when offenses are separated and each of them is less than 6 months, if the aggregation of those trials exceeds the 6 months time frame, then it's again a trial by jury. And the case law for that is Bloom versus Illinois, as well as Ex parte McNeamy. Again, this is the issue why the South Carolina child support program is unconstitutional. It goes against the Supreme Court decision. So if anyone is in South Carolina and you are facing contempt charge, your next move is to file a motion for jury trial. That's it. You want to get out of child support, you motion for jury trial, and you demand a jury trial. That means everyone in South Carolina that's facing contempt charges or looking at contempt charges or about to face contempt charges, you need to put a motion for a trial by jury. Now, what if the judge says, oh, here in South Carolina, we do it differently. We don't follow anything. This is not federal law. That is wrong. The Supremacy Clause of the United States says very, very simply, federal constitution and federal laws precedes state law. It prohibits states from interfering with any federal or government program. The Title 4D program is a federal program. Therefore, South Carolina cannot institute some law that says we can punish you over the 6-month time frame without a trial by jury. So someone says, well, what if you're on trial and the judge says, well, I'm not going to put you away for 6 months. For 1 year, I'm going to stick with the 6 months guideline. It doesn't matter. The statute is very clear. And you ask that judge, does the rule only applies to you or does it apply to everyone in South Carolina? If you are facing contempt, then you should request a jury trial. So here's our quiz that we ask, what is called motion to vacate an order in jurisdiction. There are many of you out there that are filing what is called motion to vacate or Federal Rule 60 or 60B. Well, we did additional research into this because we have reviewed many documents that says motion to vacate, and yet the courts are not honoring those, and many of you men are confused. So here's a case in South Carolina again, right? So this is the definition from this case. The voluntary appearance of a defendant in a case where they made motion to vacate to set aside the attachment or the proceedings gives the court jurisdiction. Wait a minute. If you file a motion to vacate in South Carolina, and this is the first time you are before the court or magistrate, you give the court jurisdiction by that filing. So here's the ruling from the state. Any action by a defendant which really amounts to an intent to be in court is also voluntary appearance. Why? Because you failed to conform to the procedures required for a defendant who would preserve jurisdictional questions after an adverse ruling. The case law is Ex parte Perry Stove, Stephen versus Ringling, South Carolina State Highway versus Ismain. This is the decision in South Carolina. If you file a motion to vacate, it is not the proper instrument in which to preserve your jurisdiction. I hear guys say this all the time. I have jurisdiction, or I file a special appearance, and not if you file a motion to vacate. So as we do on this channel, we do research. And we looked into this motion to vacate by Ex parte Perry Stove. When we looked up that case law, it reads, the judgment is not void when the court has jurisdiction of the parties and the subject matter, again, subject matter, and the voluntary appearance of defendants by a motion to vacate an attachment gives the court jurisdiction over that defendant and the parties. Now, what's interesting is that this decision, Ex parte Stove Company, was made in 1895. People on this channel will say you are challenging all the gurus on the web, saying, "Oh, you don't know what you're talking about." I am not here to challenge anyone. I'm here to bring you the facts. If you file a motion to vacate in the state of South Carolina, you are giving the court jurisdiction. And that decision was made in 1895 and it stands till today. So it doesn't matter whether you're an expert in child support for 15 years, 20 years, 5 years. If you file, or men who file motion to vacate, you cannot challenge jurisdiction. That includes personal jurisdiction or the subject matter. So this is the quiz that I'm talking about, the big bonus, which is save your money, save your energy, save your time. It is a waste of time. If you want to challenge jurisdiction, motion to vacate is not one of those instruments that you use. So here we are, the section what we call coll action. What do you do now? Okay, if you're in South Carolina and you're about to face a contempt charge, our suggestion based on our research, you should be quoting Illinois versus Bloom that says you demand a jury trial. And if the officer or the court says, oh, you're not eligible for it, tell them that is not true. The Supremacy Clause says if I deserve a jury trial, I should get a jury trial. Second, for many of you who are trying to escape child support, you're doing many instruments. You're either buying it off the internet or you're buying it from someone and you're spending your time putting it together and all that goes with it and the packaging and the mail fraud. If you use the instrument motion to vacate, it is not the proper instrument to challenge jurisdiction. It's been in the state since 1895. So if you want to challenge jurisdiction, not just in South Carolina, but anywhere else, motion to vacate is not the tool. And we'll do more stories about what is the proper tool to use when it comes to jurisdiction. So here we are at the end. If you disagree with anything that we've just stated for South Carolina, we point out 2 issues and 2 problems with South Carolina that you should be aware of if you're going to win your child support case. But we're also asked, please donate to this channel. Help us continue to bring you the research. We providing you this bonus of the motion to vacate is not the proper instrument saved you a lot of research to find an 1895 case law. So here we are at the end, and thanks for listening, and look forward to giving you more information about how to defeat the child support program. Thanks. Have a good day.